floor is yours.
Thank you very much. I want to thank you all for inviting me. I'm sure this is going to be interesting to me and to my work. And I do apologize for me speaking English, speaking this lingua franca, which today is becoming the colonizer language, but I don't feel confident enough to speak in French. So, but again, if you want to speak in French, I understand. I don't know how many of you have read the text. I don't know. I don't want to take your knowledge of the text for granted, so I will go through it and will comment on it at some junctures in order not to bore those who have read it in advance. And as Antoine was saying, this is very much concerned with the distinction between the distinctiveness of law. Even though, as I will say, to me, the distinctiveness of law is something very specific, which hasn't got to do with the distinction between law and other fields, but can be understood only from a general perspective of social theory. This is why today I won't be talking about what we call the formal structure of law in terms of rules, in terms of the normativity of the law, in terms of the cohesiveness of legal rules, or in terms of the practice which organizes the activity of judges. As you might have understood, all these are solutions to the problem of the distinctiveness of the law put forward by prominent authors in the past few decades or in the past century. This is a dead end, in my view, because from within a legal perspective, one cannot really understand what makes the difference between law and other fields. So my main approach today will be the distinction between the social and the legal. And I like, do you think I can use the whiteboard? So, I'm not entirely sure this is going to be of any help, but because my handwriting is very bad, is there otherwise I can just, I hope you can imagine what I wanted to. But it is, I think it is. Okay, so you should imagine the two realms of the social and the legal. I'm not saying, this is an important caveat, I'm not saying that the social and the legal can be really distinguished to the extent that you can point to the social and you can point to the legal. I'm interested in the interplay between the social and the legal, because it is the best way to understand the traits that make the law the law. And what I will be doing today is to try and see what prominent authors in the field of legal theory, but not only, have said about the relationship between the social and the legal. At the end of the day, or at the end of the paper, you will see, I believe it is truly important to provide a strong conceptualization of social normativity, which is broader than legal normativity. I will come to that, but so the first thread will be the relationship between the broad social, the social realm, and the legal. Is the legal realm within the social? Can it be distinguished from the social? Is outside the social? What is the relationship to the social? So, and this is a way to account for many diatribes in legal theorizing, and to also to spot some similarities between different criticisms by different authors, like Hart and Schmidt. In my view, they said something which really links to the others' criticisms. Law and its place in society. I start with Schmidt. In my view, I co-authored the monograph on Schmidt, and I believe Schmidt to be very important to legal theory, notwithstanding his, contestable, despicable choices, no doubt about that. I'm looking at Schmitt as a legal theorist who takes issue with Kelsen's view of law. And in this monograph I say, well, we have been very busy with Schmitt's understanding of decisionism, on exceptionalism, and so on. Together with my colleague Andrea Salvatore, I claim that the most important part of Schmitt's legal theory is what is said in the 1930s about legal institutionalism. He sort of converted to legal institutionalism after encountering Santi Romano and Maurice Oriou, and he provided a very strong institutional theory of law, which is called concrete order thinking, because the Nazis didn't like the term institution. This is the main reason why he didn't call it institutionalism. So in what I believe to be the core book of this period, on the three types of legal thinking, 1934, Schmitt bemoans what? The fact that positivists provided a very misleading understanding of the law. And he said, the crime, in an important juncture, he said, the crime is not disorder according to positivists, but mere fact type. Fact type is a word which is very badly translated into English and also into Italian. Well, it is specifically what Kelsen had in mind when he talked about specific legal categories like manslaughter, theft, and so on. So it is a fact type, what in Italian we call fatti specie. There is no precise equivalent in English, but I think a specific type of fact. What does he want to say? He insisted that positivists regarded crimes not as socially reprehensible harmful behavior, but as the artificial production of a set of coercible actions. So Schmitt's penetrating investigation into the deep nature of legal positivism lays bare the abstract and artificial character of the idea of law endorsed by most legal positivists. Legal positivists, Schmitt says, see law as an impersonal order. That is to say, a technical, intellectual, pre-designed device intended to describe social reality according to a limited set of categories. I mean, this is very important for us to understand the distinctiveness of law, or at least what some key authors thought about the distinctiveness of law. If you have in mind Kelsen's basic norm, not the basic norm, Kelsen's basic understanding of what a legal norm is, it would be if C then X, if something happens in the social realm, then coercion has to be applied. And we know that according to Kelsen, the primary legal norm is the part in this statement which concerns coercion. So the primary legal norm is the force attached to something which happens in reality. And this is a very artificial, according to Schmitt, understanding of the norm, because in Kelsen's view, the legislator selects some type of behavior which are not legal or illegal. There is nothing inherently illegal or illegal in this type of behaviors. The legislator wants to discourage them, and to do that, he adopts a particular specific machinery, the legal machinery, and attaches to these specific actions a given quantity of sanction. But the core law, and this is very important, the core law is the sanction attached to the condition, what he calls the condition, what allows the law to be enforced, applied. So Kelsen's famous portrayal of coercion as the core element of legal phenomena leads to the understanding criticized by Schmitt. According to Kelsen, legal norms neither mandate nor prohibit conduct. So this is important about the relationship between the social and the legal. Kelsen is convinced that law shouldn't be concerned with what happens in reality. This is a problem of effectiveness. We know that Kelsen in the US changed his mind at one point in the 60s, in the 50s, but I'm looking at the Kelsen of the 30s, of the pure theory of law. And he said, look, as a lawyer, I'm not interested in what people do when they comply with the law. The law should be concerned with the type of sanction that has to be associated with these facts. Whether these facts happen or not in reality, this is not for the lawyers to comment on, for the jurists to comment on, for the legal theorists to comment on. So I would say, I would redescribe, this is very contested, but I would redescribe a legal norm in a Kelsenian point of view as an attribution of meaning. It means what it calls imputation is an attribution of meaning to something which, from a legal point of view, has no meaning of its own. Therefore, what actually happens, as I was saying, in the social realm, or rather, what rule abiders comply, whether rule abiders comply or not with legal norms, has no legal importance, legal significance. This is why Schmidt said the crime, without quoting Kelsen at the time. Kelsen already had some problems with the Nazi, so it wasn't very important, or it wasn't very strategic to quote Kelsen. Schmidt was saying the crime, I'm rereading his criticism, is not disorder, but mere fact-type. Why does he want to underscore this element? Kelsen, in the pure theory, states that external circumstances are events perceptible to the senses and governed by causal laws. So this is something for physicists, something for hard scientists to comment on. What happens in the domain of the social is nothing but a chain of natural events governed by the laws of mechanics. Then, this is very important, there are, and this is the core of Kelsen's positivism, there are no pre-legal action, no actions which can claim to be legal or not. So there are no models of conduct, lifestyles, that should be encapsulated by the law, enforced by legal norms. So, famously, we know that Kelsen believed any conduct could become legal, not because of an alleged pre-legal normative value, but because this conduct has been assigned a sanction. Kelsen says what makes such an event legal, a legal act, is its meaning, the objective sense that attaches to the act. Now, according to, I want to say this is very important. No, not for the sake of Kelsen's interpretation, but for understanding why it's so important for some legal theorists to spot, to identify a distinguishing mark, and why, according to Schmidt, this is only a political concern, not a legal concern, contra Kelsen's own understanding. So according to Schmidt, this view of legal norms as technical instruments completely detached from what society produces in terms of models and standards is entirely mistaken, is entirely misleading. Law is mistakenly regarded as a pure intellectual artifact in the hands of officials who use legal norms to do what? To ascertain what happened in a given time and space, to do what again? To decide whether a sanction ought to be applied. So, in this juxtaposition, two opposing and irreconcilable understanding of legal rules emerge. Schmidt thinks that the building blocks of law consist in the rules and models developed within a concrete formal life and its well-established institutions, and hence sanctions are meant to protect, to confer a binding force on these rules and models. He was very, very afraid of pluralism becoming something dangerous to the community. On the contrary, Kelsen believes primary legal norms to be the primary legal norm to be the sanction that renders the prohibition of a given act described in the legal proposition into a rule. Kelsen believes that the primary legal norm is nothing but the amount of coercion that within a legal population is attached to a given action, and that therefore makes this action illicit. Now, I invite you to draw a line, an imaginary line in your mind, because what I'm going to call continuists and discontinuists in a few moments can be put in a line. If you imagine two ends, at one end continuist, at the other end discontinuist, I would like to say that Kelsen is the most compelling discontinuist, and Schmidt is in between these two extremes. I will explain to you what this means in a second, but you might have understood that continuists are those who believe that the social and the legal are profoundly intermingled, and discontinuists are those who say there is an important difference which brings about a chasm, a gap between the legal and the social. There is no continuation, but in a sort of conversion which allows the social to be transposed into the legal. I'll come back to that in a little moment. Some years later, another figure in between, I would say, in between, Herbert Hart, addressed a similar criticism to Kelsen. So, in the concept of law, Hart wanted to dispute the counterintuitive association between primary rules and sanctions. Among other arguments, he claimed that primary rules are not purely artificial constructs. He was busy with showing that primary rules and secondary rules are different types of rules and that have a different nature. So, according to Hart, primary rules incorporate pre-existing social models, while secondary rules do not. In other words, Hart was convinced that primary rules mandate or prohibit conduct which is considered good or bad, whether or not they are accompanied by a legal sanction. So he was saying against Kelsen, you believe that the law, the legal element, lies in the sanction, while you can see that in many primary legal rules, incorporate models of conduct which within the social are considered to be wrong, whether or not there is a sanction which determines their legal quality. So, and he says about primary legal rules, it is logically possible and might be desirable that there should be such rules, even though no punishment or other evil were threatened. It might, of course, be argued that in that case there would not be legal rules. This is very tricky of art, but I'm not going to comment on that. Nonetheless, we can distinguish clearly, Hart says, the rule prohibiting certain behavior from the provision for penalties to be exacted if the rule is broken, and suppose the first to exist without the latter. So he is saying the primary legal rule, contra Kelsen, is not the coercion which is attached to the act, but the act. This is very important. This tells a lot about the relationship between the social and the legal, because Hart is saying the legal, my dear Kelsen, doesn't lie in that quantity of force which you associate to the act. Lies in the act, so lies in the social. So if you imagine a line dividing the social, and the legal, according to Kelsen, what happens? The legislator selects, or I use selects because they are not created out of nothing, selects a set of behavior, and the legislator drags these behaviors into the legal field by associating coercion to these acts. So there is an act of translation from the social to the legal. Hart says, not at all. It is already legal. There is at least a seed of legality. Okay, when he says someone might argue that they are not legal, but there is at least a seed of legality already in the social, because social normativity is the cradle of legal normativity. So, and he says, law, according to Hart, law is not a mere set of provisions, but a series of social standards developed and observed in the social realm that law incorporates and makes binding. And we know that, according to Hart, what makes a legal rule legal is that the legal practice ruled by the Constitution does the trick. I mean, translates some social norms into legal norms. Now, I believe they completely, whether or not they are right, and conceptually, I believe they are right, they fail to understand why Kelsen was so concerned with this understanding, which is very counterintuitive, incredibly counterintuitive, and they point to matters of fact. I mean, people believe in standards, comply with normative standards. How can you say that there is no relation at all between manslaughter in the social realm and manslaughter in the legal realm? They failed, Hart and Schmidt failed to understand why Kelsen was so concerned with it. I will come back to that afterwards. I would like to change scenario now. I've been talking about very famous diatribes among very important, notable legal thinkers. Let me move to a renowned legal anthropologist, not as famous as Schmidt, Kelsen, Hart, but a very intriguing legal theorist, anthropologist who wants to become anthropologist, Gordon Woodman. What I would like to say is we are talking about the same thing. Whether or not they make it clear, the problem is just the same. Gordon Woodman is one of the most prominent representatives of what today is called legal pluralism. He is particularly hostile to the idea that law is a specific, separate field of social reality. He founds his legal theory on observation, so he's truly an anthropologist. He observes populations, he tries to understand how customary laws work, and he comes up with this idea of law without any strong theoretical foundation, but theoretically it is very, very interesting. So he denies that we can really find any element in social reality able to unveil the difference between a genuinely social and a genuinely legal domain. You might say, understand, let me say that in Ghana, where it works, it still works, there is no understanding of law close to our understanding of law in the West. This is not true for a variety of reasons, not only because customary laws are very pregnant with legal meaning, but only because it was heavily, there is no real customary law. It was heavily influenced by English law. So there is a strong understanding of law close to that which we have in the West. So according to Woodman, law is nothing but a set of rules backed up by social observance and followed by the members of a given population, and that they serve, these rules, these standards, serve as public standards for mutual assessment and criticism. if law has to be conceived in this way, then the conclusion is that in all given geohistorical context, there are as many laws as populations with their own set of rules, while their members, the members of these populations, can belong at the same time to more than one population and can accordingly be attributed different identities. So Woodman makes it clear that this view may cause havoc in the ambit of legal study. No science, he says, that is supposed to account for what law is, neither legal science in particular, nor social science in general, is actually able to indicate the difference between what we call law and the many sets of normative orderings present in society. So, again, if you refer to the imaginary line I drew before, Woodman is at the end, at the very far end of continuists. He says that in reality, the distinction between what we call law and the other many normative orderings present in society is a matter of, I don't know what, it depends. History, power differentials, legal construct. It might be us who want to find the distinguishing mark on something we are desperately looking for. But what he says, his point is that as a matter of social observation, we cannot really find the distinguishing line between etiquette, between table manners, between rules governing sentimental relationships and the law. So, what I have said so far can be summarized as an opposition between two extremes. While Kelsen advocates the basic distinctiveness of law, which cannot be reduced to any type of ordering, Woodman regards the distinctive line between the legal and the social as arbitrary, and shows that its conceptual justification is just a chimera. As I said, I call these continuists, those who see law as an artificial and technical device which occupies a special place in the social realm, whereas I call continuists those who believe that law belongs to a continuum of social orderings and has no special place but the one which is temporarily, it means in the here and now, but perhaps not tomorrow, that is temporarily assigned to it on the basis of historical contingent factors. So I insist on the historicity and the contingency of this line, because one might come up and say, well, the distinction between law and no law is just a matter of history. We have this distinction, but it is not conceptually justifiable. Many legal theorists do not make this distinction and just mistake one plane for another. I mean, it is important to be able to understand whether your argument is there is a distinction and this is contingent, or there is a distinction which is justified. Once and for all, and this is Kelsen's position. This is why he is the staunchest this continuist. This distinction is intellectually, conceptually, theoretically justifiable. This is the duty of the pure theory. So let me explore the extremes, because what I'd like to say is I'm very sensitive to the conceptual reasons of legal pluralism. I think they made a lot of points that disprove many assumptions of mainstream legal theories, not only positivism, but they end up in a series of conundrums that they are not able to solve. And I'd like to say now that they make a few points, but at the end of the day, they fail to understand to indicate, as Wittgenstein would have it, the fly, to indicate to the fly the way out of the bottle. So we end up in this bottle and we cannot really get out of it. At one end of the spectrum, this continuum, we have Kelsen he says the law is something altogether special, which must be carefully distinguished from other non-legal normative entities. Law is a technique whose hallmark is the presence of assumption conferring a special legal meaning to a given action. Against those like, for instance, Eugen Ehrlich, and this polemic with Ehrlich is very important. Those like Ehrlich argue that sanctions are regularly applied in many spheres of social reality outside the legal domain. Against those who say that, Kelsen remarks that coercion is not to be conceived as the motive which urges someone to comply with a legal norm. Again, why I now want to make a point about Kelsen's being very concerned with the distinction, and he says, because Ehrlich criticism to Kelsen was, if you, as a sociologist, I can see that in many spheres of social life where there is no law at all, where courts are not involved by any means, there are many sanctions being applied, and people comply with very much stricter rules than legal rules, and they work perfectly. They are the life. And Kelsen replies, I'm not concerned with how coercion works as a social mechanism. I'm concerned with the conceptual role of coercion. Why? Legitimate coercion is the sanction that a body of official legislators formally associate with a given norm under the guidance of the basic norm, which is the peak of any legal system and determines who is entitled to issue valid legal norms. And this is, according to Kelsen, the truly distinct, the only distinctive, truly distinctive feature of law. If we fail to hold onto it, we just lose any possibility to distinguish law from other normative orders. He says, if we ignore this specific element of the law, if we do not conceive of the law as a special social technique, if we define law simply as order or organization, and not as a coercive order or organization, then we lose the possibility of differentiating law from other social phenomena. This is very important. This is crucial. I think this tends to be forgotten, but is crucial to current debates on legal pluralism. Current debates on legal pluralism, in a way or another, start from Brian Tamana's seminal criticism to legal pluralism. I don't know how familiar you are with these topics, but in 1993, Brian Tamana, now he had a change of mind, and now he's a legal pluralist, but he was very critical of legal pluralism. And he came up with this idea of the Malinowski problem. He studied Malinowski, many anthropologists. He was saying, look, those who talk about legal pluralism are legal anthropologists. And they not only do they interpret badly Malinowski, but they take for granted what Malinowski said about law. And to get a very long story short, Malinowski said that the law is just a social mechanism. So, in reality, the law is what allows a society to stick to their basic rules of morality, reciprocity. And so he refers to this tendency of legal pluralists to include any type of social rule into the category of the legal. This is a very sweeping statement. I'm not entirely sure this applies to all legal pluralists, but he wanted to launch a very bold attack to legal pluralism. What I want to say is that Kelsen's in a way goes deeper than Tamana, because he doesn't want to say that the differentiation between the legal and the social must be preserved in the light of his justification of the role of coercion. So it is not. It is neither a political matter nor a matter of the integrity of legal science. It is entirely a matter of legal pluralism, of the possibility of denying legal pluralism, because coercion is the only way for us to determine what is the difference between the legal and the social. Now we are faced with a heap of problems, because a few people would say, but what really distinguishes legal coercion from social coercion? But I cannot go into the details of that. I just want you to have clear in your mind Kelsen's main concern. So his goal was that of portraying law as a specialty, which is incomparable to the several set of rules which comprise a given society. Now, I'm being a bit hasty about Kelsen. I'm not going to explain or to attack or to defend him, because I want to say his point is completely right. Perhaps he failed to understand how to justify it. He took it for granted. He said he never explained why we should be so preoccupied with distinguishing law from other social orderings. But Kelsen, in my view, said something very interesting, indirectly, said something very interesting about the law. And what Schmidt didn't like was that Kelsen had an understanding of the law as a mirror which allows officials to share a common account of reality based on a particular set of categories and procedures. What I will say, to give you some clues to what I'm getting at, I wouldn't like to come across as a bit opaque. Kelsen, without having the vocabulary, was saying crucial to the existence of the law is what philosophers call the direction of fit. If you are familiar with the distinction of the direction of fit, that is to say, something being adequate, is that something you are familiar with, or should I? So the direction of fit is crucial to speech act theory. When I say I claim it is raining, my SR would have my words must square with what happens in reality. So in order for my statement to be true, the word, what I say, must fit what happens in reality. I mean, something concretely observable. Okay, so, and we would say the direction of fit is word to world.
Direction of fit.
Direction of fit.
FIT.
Yes, exactly. But if I say, can you please close the door? In order for my statement to be not true, but felicitous, there should be a direction of fit from the world to the word. It is the world which must fit my word. Okay, so my statement. When you close the door, the direction of fit is happy, Austin would say, because the world now is exactly adequate to my statement. This is very important. I mean, this is crucial to the law, because what I will be saying, and I could recall a bit of Latour here, not entirely, but the law is the only science, I would say knowledge, which doesn't care about the direction of fit of the word to the world. It is not like science, you know. It is true the science is also a field of power, a field where many factors are at stake, but you cannot entirely disregard what happens in the world, while the law, I would say, in my view, was Kelsen's intuition also, can be completely, has to be completely disinterested, uninterested, and disinterested in what happens in the world. I will get back to that. So, I can skip Schmidt's criticism to this view, because he misunderstood Kelsen. He said this is very political, this is by no means a legal understanding of the law. But let me say a few more words about whether or not this distinguishing mark is historical, contingent or not. What I was saying about the direction of it is crucial, because I'm saying perhaps there is a way we can justify this way, we can vindicate this way, to justify, to identify the distinguishing mark of the law without having recourse to factuality. I'm not denying that the distinguishing mark of the law can also be historical, factual, can also be related to factual traits. Okay? And of course, if we study, I'm very fond of history of the law, and if we can appreciate the many differences between the concept of law throughout medieval, modern, and contemporary history. So it can be contingent, but there is a way to vindicate an intellectual, a conceptual distinguishing mark. But, and here comes my criticism to legal pluralism, they, in a way, they took the right path, but were completely blank to the reason why the law should be defended. Now, again, I don't know how familiar you are with the works of prominent legal pluralists such as Sally Fatmoor or Sally Engel-Mary. They had this preoccupation at the end of the day. They provided very compelling understanding of legal pluralism, but they all ended up saying, well, we have dismantled legal positivism. They believed they had, and I believe they made some points. But now we can sense it was a worry more than a conceptual argument. We have a sense that we should still distinguish between state law and what we are saying that is law. We still should be able to find what differentiates the law of the state from the many customary laws, religious laws, which we claim to be legal. An important, absolutely compelling view, perhaps one of the most compelling views in the field of legal pluralism, is Mark Galanter's. And Mark Galanter's is extremely interesting because he swings continually between, well, we should find a way to defend from a conceptual point of view the difference between law and non-law, on the one hand. On the other hand, he keeps on saying, but in reality there is no criterion. In reality, if we look at reality, legal pluralism is the reality. So, is there any way? So, his article is absolutely seminal, absolutely enlightening and clear, but you can find the sort of inner paradox whereby he oscillates continually from saying, look, this could be a distinguishing mark, and on the other hand saying, well, but I can't really defend it from a practical point of view. So, at the end of the day, he said, he took stance and said, by observing the history of the law, by studying the history of the law, by observing the way law works in reality, in courts and outside courts, I must say that it's the difference between the law and non-law is a struggle over meaning. A normative ordering which claims to be the only legal ordering and engages in a war to get rid of the others. So it is only a historical circumstance, contingency, based on one's particular ordering, one particular ordering's willing to be conceived as the only legal ordering. Finally, in the paper I sent you, Woodman goes even deeper and says, I provide the very final argument because I show you that what you call state law is a customary law. And he provides a very interesting Hartian argument. In one article, I show the connections between his argument and Hart's argument, and he says, if I manage to show that state law is nothing other than a customary law, and then that the true formal law is customary law, I completely vindicate legal pluralism. There is no grounds, he will say, to say that state law is something very specific, that law is something very specific, because at the end of the day, he said, state law is nothing other than a customary normative practice made up of secondary legal rules, observed by what he calls relevant population, that is officials and others who operate the various state agencies, whose activities are governed by secondary rules, as I said, when they are called upon to recognize valid primary rules and to apply these primary rules for dispute settlement. Now, what is the problem? To recap, I presented Kelsen's view, and I underscored his intention to provide a conceptual, not only factual justification for laws nature being entirely based on the rule of coercion. In between Kelsen and those whom I talked about so far, there are Schmidt and Hart, and they say, well, it is true that law and law and the social are separate, but if you look at it, if you look at legal rules, there is an evident connection between legal rules and normative rules in the social realm. And then the contrarians say, not only is there a connection between them, but there is no way for us to say that the given rule is legal or a given rule is social. On the one hand, I couldn't go into the details of the argumentation, but I follow legal pluralists insofar as they say, if we look at the normative structure of the law, we fail to identify a distinguishing mark. What is the main drawback? It is difficult to say because there could be many ways to address my criticism now, but I cannot even mention them. But in my view, the main defect of the continuist's view is what I call Romano's dilemma. Now, in this paper I talk, I'm very happy to know that you are acquainted with Santi Romano's theory. I believe Santi Romano's theory to be one of the most compelling theory in the field of legal institutionalism and legal pluralism, and my British colleagues, Anglophone colleagues, are very surprised to know that he was the first to connect legal pluralism and legal institutionalism. And he said 100 years ago that legal institutionalism leads naturally to legal pluralism. So, why Romano's dilemma? In l'ordinamento giuridico, the legal order, Romanos argued that the law is a widespread phenomenon which cannot be confined to official courts and parliaments. Law has a constitutive and organizational nature, which Romanos signifies with the term institution. In a way, Romano, in my view, is the strongest, perhaps not the most refined. I believe Woodman to be the most refined, but Romano is the strongest continuist because he provides a full-fledged understanding of what makes, from a legal pluralist view, what makes a given state of affairs legal. Because I don't know how much how familiar you are with that, but it says the law is nothing but an institution. What is an institution? Institutions are functional devices that make a given set of rules outlive those who transitorily follow them. Institutions are webs of rules, roles, and functions. Within these institutions, roles are indirectly addressed to individuals. That is to say, are addressed to individuals insofar as they occupy a given role and perform the functions related to their role. So, to be brief, law is nothing other than an objectified set of rules which draw the boundaries of roles, which are occupied transitorily, are performed transitorily by individuals, but these roles exist even when individuals die or when these individuals change their role. So it is the structure. So Romano says laws, legal is synonymous with organizational. Law is organization. Law exists whenever two or more people are able to construct, to build up a structure which doesn't depend on their existence to continue to be the structure. But this view ends up in a series of dilemmas that he failed to address. From 1918 to 1948, the second edition of L'ordinamento giuridico, Romano tried to reply to the many criticisms by those who were saying, well, you are saying that law which anticipates the many debates in the legal pluralist scenario, you are saying that the mafia is an order. You are saying that there is no conceptual distinction between state law and a criminal gang. And he was saying, well, from a conceptual point of view, there is not. But why? What is Romano's dilemma? I don't know whether I tend to distinguish between two levels of this dilemma: a conceptual level and a pragmatic level. I believe this criticism to Romano to apply to all forms of all true forms of pluralism. I mean, all pluralist understandings of the law incur this dilemma. My friend William Twining says, I don't bother, but from a conceptual point of view, there is no way to get out of this dilemma. So you can well avoid bothering, but you must provide a theoretical argument if you want to unravel this impasse. On a conceptual level, my question is, on what basis does Romano argue that the state, because at one point, I must say that he is very, as an important judge, he oscillates between saying, well, but the state law is the institution of institutions, and from a conceptual point of view, it is just like the normative structure of a criminal gang. But from a pragmatic point of view, the state, without state law being enforced, there wouldn't be any law of a criminal gang. So, from a conceptual point of view, my question are, on what basis does Romano argue that the state represents the institution of institution? You will see that many legal pluralists, after incurring this dilemma, tend to say, but there is a pragmatic reason for us to hold on to the validity of the state law. There is, whether or not we can justify conceptually the difference between law and non-law, there is still a reason for many reasons, political reasons, distributional reasons, and reasons based on equality, to say that state law is the institution of, or international law, it depends on the view on superstate law. So, on what basis can this type of law, what we call law, be represented as the institution of institutions? do not state institutions need the state in order to exist or blossom? Or is the state merely required in order for them to solve their conflicts with other institutions? My colleague George Pavlakos now is coming up with a new pluralist understanding of the law. He talks about proto-legal relationships, and he says these are the cradle or enforceability. So where every relationship which is based, to be very rough, on rules of reciprocity are legal, are candidates, good candidates to become legal. And when I talk to him and say, well, why should then prohibit some relationship, those who some believe to be detrimental to society, and allow others? He says, well, there are a few reasons based on the external reasons, based on the possibility for a society to live peacefully and to coexist. There are many political reasons for saying that there must be a common law at the end of the day, whether or not one, even if one is a pluralist. So Romano said something like that. The law, state law, allows more normative orderings to coexist. But how would you, from what point of view would you reply to this question? That is, if the inner structure of all groups and organizations can be legitimately called law, why should criminal gangs or unlawful organizations refrain from combating the law of the state? So, from a conceptual point, from a pragmatic point of view, you could say, if you pursue your ends, while speaking to the mafia, if you pursue your ends, you prevent our society from existing. You draw it to a close from a pragmatic point of view. But from a conceptual point of view, you are saying your claim to be fighting an unjust law, the law of the state, what you see as an unjust law, is conceptually justifiable, entirely justifiable. This is the truly pluralist view, which I believe to be very strong. Now, this is the core of Romano's dilemma. Is the preeminence of the state, of the law, state law or international law, merely because I believe this argument to apply to what is called global legal pluralism? Is this preeminence merely due to power differentials by which the state manages to subject other non-state institutions? Or is due to some special traits which state institutions lack? Now, I've got less than 10 minutes to explain my way out. I will be brief because I'm sure this will come up in our discussion. Am I right? You said?
Sure, yeah, perfect. Yeah.
Well, my first suggestion is to switch focus. What I say is that legal pluralists are entirely compelling when they talk about the differences between law and non-law, non-legal and legal orderings in terms of law's formal structures. There can be rules, there can be primary rules, secondary rules, or the job of legal officials, or the practices, the institutions. We have plenty of theories about what is law's authority. I mean, I think I'm ringing many bells, from McCormick to Raz to a lot of others who are trying to say there is still a distinguishing mark. I mean, the arguments put forward by legal pluralists is, in my view, much stronger than these. But we should look at another aspect of the law, which I call law's, the knowledge which underlies law. But we fail to understand the specific trait of this knowledge if we unless we look at the direction of it I was mentioning before. Let's look at law as a type of knowledge, and let's look at what law does. I know this is very tricky. When I talk to legal anthropologists, they come up with all sorts of criticism that are opposite to the criticism I receive from legal theorists. But let's try to look at the way law works. And as Antoine was saying, I'm trying to use the recognition of homosexuality as a case in point to show how the law works. Perhaps I can, you know, I can go off on a tangent and try to say to give you my argument, referring to homosexuality. This could be even more intuitively understandable. What is my argument about the recognition of homosexuality? My very critical argument on same-sex marriage. I studied the trajectory of same-sex battles in a few jurisdictions, in the US, in the UK, and in continental Europe, and there is a common core in this trajectory. What I call the battle from the street to the courts. And I say, why are so many queer theorists and many left critics, radical critics, so concerned with what they call a process of normalization? So in the 70s, in the 60s, the 70s, homosexual groups wanted to dismantle society from outside, wanted to get rid of the system to dispose of many institutions of the good society, that is the school, marriage, and psychiatry, and so on, because they were connected. They were collusions against a freed understanding of sexuality. So they colluded for a very repressive understanding of sexuality. But at one point, homosexual groups changed their view about the good society, and they said, well, we are no longer interested in getting rid of society. Rather, we'd like to get some rights that good citizens enjoy. I think we are good citizens, we deserve a few rights. And the new battle became the battle for gay marriage. No longer a battle about the legitimacy of some sexual acts, but the new battle was the idea that all good citizens deserve the rights that heterosexuals have. How come this happened? Many critics are hold neoliberalism responsible, conservative policies responsible. There is a process of normalization. Now homosexuals are becoming less and less sexual and are concerned about love, intimacy, respectable relationship based on a specific narrative of mutual fidelity, lifelong commitment to each other. In the past, they believed it to be just a hegemonic construct to be disposed of. My argument is this happened because the law kicked in. How? There are a few theories to say who study how the lawyers took over. What happened? They, at one point, there are many factors, not only that, but this is the driving factor, I would say. Battles for a liberated society fell short, and lawyers decided to take over, to say, well, the most we can get is what the law assigns to respectable citizens. But to do that, I must reframe our claims. There are interesting studies on how these claims were actually reframed. That is to say, I must make you legally speakable, I must make your claims legally legible by the law. It means I must use the language of the law for your claims to be heard by judges, and for you to obtain your rights through litigation. Because legislators usually lag behind, and through courts, through litigation, through cause lawyering, I can get your right. Now, by studying this movement, this social movement, I studied the way law as a set of categories, and here comes my understanding. Law is a particular knowledge based on a set of categories whose direction of fit is the one of the word to the world. What does it mean? In an interesting, enormously interesting decision by the Italian Constitutional Court about the possibility of extending marriage to same-sex couples, they said, we are agnostic about that. We don't take issue with that. Why? Because the law doesn't have a legal fact type for us to discuss about same-sex relationships. Because the legislator decided not to introduce in the law a legal fact type. So what happens? We cannot talk about same-sex relationships. We lack the language to talk about this issue. There is no category for us to say whether this is legal or not. This is a non-legal problem. They said, because in the Italian jurisprudence, this is a non-existent problem. It doesn't exist. It means we cannot speak of it legally. As members of our society, we can have different ideas about that. Perhaps they deserve to be taken into consideration by the legislator, but legally it's unspeakable. So law, they seem to be accepting, is a set of categories which allow to describe reality in such and such a way. And I say, this is a productive circularity. It is circular because if the law has a category to describe something which happens in reality, this something can be described legally. And I say this is the performative element of the law. The performative means that the way in which the law settles dispute is by describing what happens in reality through the legal language. This is the trick. The very same description is the solution to the case. So why is law completely uninteresting in what happens in reality? So, because the way the law mends the rift in the social realm is this very redescription of facts. What happens? The parties agree on a language. There is a paradigm of argument. They agree that the fact must be redescribed and translated into this language. And as the jurist Alphenus said, the law is inside this language. If I can redescribe this fact with the legal language, the case is solved. If I cannot, there is no way to solve the case legally. So it is a matter of politics and this is this continuous argument. This is what Kelsen was getting at. Of course, you wouldn't agree on a single word of what I'm saying, because this is not your theory. He doesn't make his case though. This is this continuous element. Law as a knowledge, which doesn't claim to be describing something, is entirely artificial. Of course, you might say law has to talk about something which happens in reality, of course, but this is another matter. I mean, once it is translated into the legal language, the direction of it changes. The direction of it, or something which has been produced by the legislator, is from the word to the world. So today you might be aware of the Roman Mafia in these days, a big fuss about that, and they are saying we must change with the language we have. Lawyers the prosecutor made a mistake. He described what happened these crimes by using the word mafia. He's not going to make his case because this word doesn't square with what happens. This will leave them off the hook because the legal fact type must be revised for it to be able to describe these crimes. So the polemic now is the fact type able to describe what happened, able to encapsulate, to capture what happened in reality? So this is my argument. Legal categories is give form to a stock of knowledge. This stock of knowledge is used by legal experts to solve cases by overseeing the process of conversion, whereby what the facts that originated the conflict between the parties are redescribed with the legal language, and this is the legal solution to the case. It's already the legal solution to the case. This is a very bold statement, a very bold claim. I'm open to all sorts of criticism. I hope to reply to them. I will leave this to that because I think this is the right moment to round up, and if you agree, I would end my presentation.